Welcome to the breakdown. My name is Allison Gill. Thank you so much for joining us. I'm here with Adam Klasfeld from All Rise News. By the way, excellent interview with Senator Sheldon Whitehouse, my friend.
Oh, thank
Um,
you so much. I appreciate that, Allison.
yeah,
Yeah,
very, very important information that came out from that. So if everybody has the time, first of all, subscribe to All Rise News, but you can also watch that. I think was it on Legal AF over on Midas?
it was. Yes, thank you. Yeah, I interviewed him recently because he's doing just a very interesting thing. We've been waiting for the DC Circuit to rule on a disciplinary complaint filed by Bondi and the DOJ that is completely ludicrous. I'm about to publish a kind of broader story on why that is. But it was filed in July, and we've been waiting for a ruling on it that has not yet come out. And Senator Whitehouse was the first to actually point out that the reason for that could be that when the circuit court resolves the initial complaint, the only person who's notified is the complainant. So he quite naturally asks, has Judge Boasberg been secretly cleared, and is Bondi not revealing why? I've reached out to the Justice Department seeking an answer on that question. I've reached out to the circuit court. And of course, Senator Whitehouse is seeking the answer to that question. He's investigating it by reaching out to Bondi herself because he thinks that the public deserves to know whether she has been tarring Chief Judge Boasberg with a complaint that has been rejected, and that the public deserves to know whether that complaint has been rejected. So I'll keep you posted on what it turned out.
Yes, maybe we can put some minds at ease. I'll go ahead and go out on a limb and say that Judge Boasberg has been cleared and Pam Bondi is hiding it
Mhm.
from the public. But we don't have confirmation on that yet. Um, but certainly, that decision has had to have come through since
Yeah.
July. But anyway, thank you for that interview. It was very eye-opening, and I hope you or the senator get an answer from the Department of Justice or Pam Bondi on that soon. I don't know that you will, maybe ever, uh, because they don't really like to, you know, amplify their losses if they don't have to. But good eye on keeping that up in the news because I think it's important because Judge Boasberg is trying to move forward with his contempt um, proceedings.
Inquiry.
Yeah. So let's talk about a couple of cases, a couple of filings, and a ruling. Let's start with the California voter roll ruling. And I think just some brief background. The Department of Justice had asked the Secretary of State of California for all of the unredacted voter records and, under certain legal um, precedents or under certain laws, saying we need it all because we have to, under this particular law or Title III or whatever, something that hadn't even come out yet by the time the law was written. But we need all the unredacted voter information. And the judge in this case put two and two together and said, I know why you want this voter registration information. And it's not because of what you're saying. And you haven't said, but let's look at the totality of the evidence of why you're trying to gather it from other places in the first place. And I think that the secretary or the secretary here in California was like, you can come and look at the redacted stuff here in the office, but I'm not just going to hand it over to you wholesale because these laws that you are citing that say give you access to this stuff actually prevent you from having access to this stuff, which is a typical thing that the Trump Department of Justice does, like when they quoted Marbury v. Madison in the immunity case. But this is a huge ruling from this judge, and it's excoriating ruling as well, saying, no, you may not have the voter rolls in California. Talk a little bit about this case and this ruling.
So this is part of a nationwide effort by Donald Trump's big lie lawyer turned chief of the Civil Rights Division, Harmeet Dillon, to get vast swaths of voter data. They have sued 23 different states, and these are the first two rulings against Harmeet Dillon's Civil Rights Division. And it's an excoriating ruling by Judge David Carter. Now, David Carter is the same judge who presided over the case of John Eastman, so he knows a little bit about the big lie. It was a civil case about the investigation into John Eastman, and in which Judge Carter found years ago that more likely than not, he and Trump violated some of the federal statutes ultimately charged against Trump by Jack Smith. So Judge Carter knows about the big lie, and he talked like he knew in this 33-page opinion. I'm going to read from it because it shows the stakes of this legal battle. It's kind of slipped under the radar, but this is the government seeking broad swaths of voter data across the country. Here's how it begins. Even after 250 years, the American experiment in democracy remains fragile. It has always been so. When asked after the Constitutional Convention what form of government he and his colleagues had created, Benjamin Franklin famously replied, "A republic if you can keep it." History demonstrates that democracy can be lost in a generation. The foundation upon which American democracy has been built is the right to vote. Brave Americans have given their lives for more than 200 years to protect this right. Now it seems the executive branch of the United States government wants to abridge that right of many Americans to cast their ballots. This is what this case is grounded in: the right to vote and the government's obligation to protect that right. The United States Department of Justice seeks an unprecedented amount of personal information to California voters from California's unredacted voting rolls. The requested information includes the names, social security numbers, voting history, and other sensitive information of nearly 23 million Californians. The people of California resist this effort. That's how Judge Carter begins his 33-page ruling. In the introduction, he says the government's request is unprecedented and illegal. So pay attention to what's going on. These are the first blows. These are the first rejections of Harmeet Dillon's nationwide effort to take vast amounts of voter data. I just read some of it out. Names, social security numbers, home addresses, voting history. Why does the federal government need all that information? That's what Judge Carter is asking. That's what Judge Carter rejected. That is what another federal judge in Oregon rejected from the bench. We don't have a written ruling from him, let alone a fiery written ruling of the kind that we're seeing from Judge Carter. But this is again, a litigation, because I won't even say it's not this one lawsuit, and it's not even these two lawsuits. 23 lawsuits from Maine to California, coast to coast, and not only fought by Democrats. You are seeing some Republicans even fight back against this proposition. Mostly the coalition is including mostly Democrats, that this is such an obscene power grab that you are seeing states across the country fight back, and a really fiery first scathing ruling from Judge Carter rejecting the effort in California.
Yeah, and Judge Carter points out later in this ruling that the former Deputy Assistant Attorney General of the Civil Rights Division, Michael Gates, said last September that this goal to get all this stuff, all this voter roll information, was so that the government could get the last four digits of every voter's social security number. And in a statement, the DOJ said that the state voter roll data provided the Civil Rights Division is being screened for ineligible voter entries. And Harmeet Dillon confirmed the DOJ had checked 47 million voter records. And the judge says, but behind this screening, there appears to be a different purpose. A lawyer working in the DOJ's voting section tasked with obtaining states' voter rolls was concerned that the data would be used not for purging voter rolls of people who aren't eligible, but for broader immigration enforcement. And he says, let's look at the, other evidence in the context. Reports from other agencies point to the federal government laying the groundwork to amass the personal information of millions of Americans in a centralized database. Palantir has been enlisted by the government to build a massive repository that can house data collected from multiple federal agencies like IRS, Social Security Administration, Department of Health and Human Services. States have also been pressured to turn over sensitive information from programs like SNAP, the Supplemental Nutritional Assistance Program, as well as Medicaid. So, viewing the DOJ's campaign to collect sensitive voter data in the context of those agreements for other types of personal information paints an alarming picture regarding the centralization of Americans' information with the executive branch without approval from Congress or Americans themselves. Now, I am old enough to remember when Republicans were really against invading people's privacy. I just watched some testimony with Jack Smith where the large swath of questions asked by Republicans were about they felt their privacy was invaded when their toll records were subpoenaed by Jack Smith in that case. What happened to the Republican Party that used to be against collecting data on Americans and centralizing it federally for whatever horrible uses they want to use it for?
Right. I mean, social security numbers are those sensitive enough? Your voting history. Why does the federal government of the United States need to know a voter's voting history in a state? The state are the administrators of the election. This is an obscene power grab. There's another, if you don't mind, again from the introduction later on, the DOJ's request for the sensitive information of Californians stands to have a chilling effect on American citizens like political minority groups and working class immigrants who may consider not registering to vote or to skip casting a ballot because they're worried about how the information will be used. There cannot be unbridled consolidation of all elections in the executive without action from Congress and public debate. That is antithetical to the promise of free and fair elections our country promises and the franchise that civil rights leaders fought and died for. It's astonishing how little this has penetrated the news cycle radar. Now, don't get me wrong, the zone is entirely flooded, but this is a legal battle playing out in 23 different states. It's an obscene amount of data led by an attorney who echoed Trump's big lie in 2020, that the judge is saying appropriately that this could have an intimidating effect, keep people from the ballot box. Do I really want to give this information to the federal government? That you know, this is a judge ringing the alarm. He talks throughout this ruling about the threat to democracy and that the quarter centennial that's as fragile as ever. But this is what he is talking about. And to your question, Allison, you talked about how this was privacy. Ostensibly, you had Republican senators claiming that they are so indignant that Jack Smith uh, obtained the toll records for a criminal investigation into who Trump was calling on January 6th, 2021, that, when the Capitol was being overrun, he wanted to know who was calling whom. And that was, part of a grand jury investigation. The contents of the call were not revealed, and that this was something that was pertinent to what he was doing on the day of the attack on the Capitol, that all Democratic states, Republican states should be up in arms. And we'd seen with a lot of the attorney general's fights, say birthright citizenship ban, the fight against Trump's attempt to rewrite the 14th Amendment of the Constitution. I would imagine that there are some Republican senators who aren't that extreme, or whose voters who put not senators, attorneys general, whose voters who put them into office want them to actually fight a birthright citizenship ban, and no one crossed lines. Here, a couple of states, not many, and it should be every single state. Texas obviously did not join. They turned over voter data, but you had Mississippi even fighting back. That's how out of bounds this is. That this traditional Don't criticize the leader. You're seeing a couple of breaks in the ranks because this is such an obscene violation of privacy that even a couple of deep red states are joining in.
Yeah, and you mentioned the chilling effect that the judge said that this could have on people registering to vote. It reminds me of a couple of laws that we have that make it illegal for one or more people to conspire to impede the constitutional rights of people under color of law. One guy was charged and convicted of those robocalls in certain cities where they reached out to Black voters and said, don't go to the polls because they're serving warrants, they're, whatever, they'll make you take vaccines, they'll, do all these other things to chill the voting rights of those people. They were charged with
Right.
Title 18 United States Code 241. Right, which is a conspiracy against rights, which is also what Donald Trump was charged with by Jack Smith for what he did in leading up to January 6th and what happened on January 6th at the attack of the Capitol. Conspiracy against rights. You cannot conspire to take someone's rights away under color of law, which is 242, which is the other statute, both of which came out of the Ku Klux Klan Act, right? So
Right.
all of these things are coming to light, but that's what that chilling effect reminds me of. And not only did this judge pick apart every single law that the DOJ claimed to give them the right to this voter roll information, he picked it all apart. The National Voter Registration Act, the Title III, et cetera. He's like, here's why that doesn't work. Here's why that doesn't work. Not only that, but he went on to say the DOJ's request violates a plethora of federal privacy laws. So not only are you not making your argument properly under the laws that you say give you the right to this, you're actually, if you did this, you're violating the Privacy Act, E-Government Act, Driver's Privacy Protection Act, all of these laws by failing to meet the requirements under each of those statutes. So this is a very powerful ruling. Um, I like to read a little bit from the conclusion, if I may.
Yeah,
We'll
absolutely.
switch over to talk about Mr. Abrego. The taking of democracy does not occur in one fell swoop. It is chipped away piece by piece until there is nothing left. The case brought before this court is one of these cuts that imperils all Americans. The erosion of privacy and rolling back of voting rights is a decision for open and public debate within the legislative branch, not the executive branch. The Constitution demands such respect, and the executive may not unilaterally usurp the authority over elections as it seeks to do here. And this reminds me of very conservative Chief Judge of the 11th Circuit, Mr. Pryor, Judge Pryor, who, when trying to decide whether or not to remove Mark Meadows's Fulton County case to federal court, in that big RICO conspiracy thing, Meadows wanted it to be moved to federal court. Pryor said, first of all, it's only for current officers, not former officers, that protection that you get to go to federal court. But you and the president have no role in overseeing elections. He was very clear about that.
Right.
And so I think we're going to be seeing a lot of that this year in a lot of different litigations where Trump is going to probably try to federalize the elections and take control over oversight of elections when those belong to the states and Congress.
Right. And just one kind of bow to tie on all this, there's one line right after what you just read that kind of speaks to our Orwellian moment, that this was brought by the chief of the Civil Rights Division and invoking what? Civil rights legislation. Here's the line. The Department of Justice seeks to use civil rights legislation, which was enacted for an entirely different purpose, to amass and retain an unprecedented amount of confidential voter data. And this up is down, down is up kind of idea that she's enforcing civil rights by grabbing 23 states' voter data indiscriminately, including your social security numbers, including your voting history. And she's doing it in the name of civil rights as the former Donald Trump echoer of the big lie. That's Harmeet Dillon's nationwide litigation on this. And I think that this is a properly indignant ruling by Judge Carter, falling in the same day. I see one of the commentators, Judge Young, a
Young, yeah.
senior judge in the District of Massachusetts. I actually listened to that ruling when he called Trump an authoritarian, where he ended the hearing speaking for the ages about, pointing to the flag and how long that flag will be here when I'm gone. I think this is not routine rhetoric by federal judges. When people say, oh, there's no real threat against democracy. Federal judges appointed by Reagan and federal judges who are very measured in their rhetoric are talking about very clearly about the preservation of U.S. democracy. And he was talking about how two cabinet members, Kristi Noem and Marco Rubio, had participated, in his words, in a conspiracy to violate the First Amendment rights of pro-Palestinian student protesters. And that was what the case before him was about. So to hear the kind of language we're hearing from federal judges, not normal, but inspiring, and in terms of really putting the stakes into clear view.
Yeah, well, their legal argument, Harmeet Dillon and what I call the Civil Rights Division, their whole theory is that the white people's rights are being somehow trampled upon, and so that's kind of the position, that reverse racism that they have long claimed exists somehow, is sort of I think the underpinning or the framework that they're using to justify all this. And the judges are like, no, bro, that's not how it works. So I'm very glad to see this ruling. And talking about trampling on people's rights, let's talk about Mr. Abrego, because we're not talking about the civil case right now. We're not talking about the immigration case right now, which is also a very interesting piece. And we can talk about that on another day, because he's not going to appeal the immigration judge because there's no removal order. But aside from that, there's the criminal case where the Department of Justice charged Mr. Abrego with 2 counts of not human trafficking, but human smuggling. And no guns, no drugs, no minors in the car, nothing else, just these driving people across state lines, which he wasn't arrested or even ticketed for when he was stopped in 2022. But they charged him with these 2 things, brought him back to the United States under that, and wanted to take him to court. Says, we will get justice, we will get justice. So, as we know, a brief background, his lawyers, Mr. Abrego's lawyers, filed for vindictive and selective prosecution, motion to dismiss these charges against him, saying that the prosecution was vindictive and selective. The judge found, what is it called, a prima facie instance, sort of, it's probable that there was vindictiveness here. We just need to have a hearing and prove it. That shifts the burden from Mr. Abrego to the government. So now Mr. Abrego no longer has to prove that he was vindictively and selectively prosecuted. Now that there's been that preliminary finding, that determination, as it's called, now it's on the government to prove that they are not vindictively and selectively prosecuting. And in order to do that, there was a hearing, and is a hearing, set for January 28th, 12 days from now, less than 2 weeks from now. And during that hearing, the government is supposed to present its witnesses and make its showing to rebut the preliminary finding that there is vindictiveness here in this prosecution. And you would think that they would bring in Todd Blanche and, Kristi Noem and all these other people, but they're not. They're bringing in McGuire, maybe, and 2 other people. But in order for the defense to have a reasonable time to rebut on cross-examination what these witnesses would say, you need all of the communications and all of the discovery and all of the information. And wouldn't you know it, the Department of Justice is not handing over any of that, including a privilege log. They said they were going to, and then they changed their mind. So talk a little bit about this filing by Mr. Abrego's lawyers saying, we don't have the information we need to go forward with this hearing. What do you want to do, Judge?
Right. And we have been here before. I will be going to Nashville, Tennessee for this hearing on January 28th. It is important to note that this hearing has been postponed twice because the government wasn't supplying discovery to the defense. So you have a very patient and a very accommodating U.S. District Judge Waverly Crenshaw giving the government, bending over backwards for the government to comply with the discovery obligations. As you noted, Allison, when he found that there was that case, that there was enough evidence to find a plausible prima facie case for that the government had vindictively prosecuted Kilmar Abrego Garcia, that shifted the burden to the government, who now has to overcome the presumption of vindictiveness. So,
Was
break.
that based on one thing that Todd Blanche said on a Fox News program? If memory
It
serves, I think
was.
you told us about that here.
Yes, he said on Laura Ingram's show that the case against Abrego began because a federal judge questioned the government. That is to say, the heart of a vindictive prosecution case, because a vindictive prosecution case means the government is retaliating against you because you asserted your rights. If the case is brought because a federal judge who is receiving the case because Abrego fought it in court, then that is the argument. He called it a telling remark. I think he might have called it a stunning remark. We're talking about a months old ruling now because he keeps giving the government another chance and another chance, but potentially crossing his T's, dotting his I's, knowing that
Yeah.
if he does dismiss this case, it's going to go up on appeal. He wants to create a record. Look, I have given the government every opportunity to provide a legitimate explanation for this. They could
Yeah,
have called every witness.
think about this like if you're trying to serve someone with a lawsuit and they are locked in their house. So you can't get to them. So you go to the court and say, "Can I serve them via email?" And then the court says, "Yes, you can serve them via email." Then you spend 2 months emailing them and you don't hear anything back. Then you go back to the court and say, Can I serve them via Twitter DM?" Because they're always on Twitter or a Facebook DM. Yes, you can go ahead. And 6 months have passed. You've tried to serve this person. And finally, they aren't responding. Then you can file for a default judgment. So if it gets appealed and they say, "No one ever tried to contact me," you have this big old long list of everything that you did to try to contact him. Well, now this judge, Judge Crenshaw, has a very big old long list of all of the chances that he gave the government to hand over the discovery necessary for the defense to properly prepare for this January 28th hearing.
Right. And so in this particular case and in this latest filing, you have Abrego's lawyers led by Sean Hecker saying that they're not getting Jenks material, basically the kind of communications so that they would question the witnesses, how to cross-examine the government witnesses. They haven't gotten emails, they haven't gotten the text messages that the government previously committed to give them. And they have argued in this and other legal filings that because the burden is now on the government to overcome the presumption of vindictiveness, it's basically in the judge's court. The judge can determine that the case should be dismissed. I think that given the kind of cautious approach by Judge Crenshaw, it looks like we are potentially headed to that a hearing toward the end of this month, and that's why I'm preparing to go to Nashville for it.
Yeah, and I think, we talk about Jinx material because McGuire had told uh, Crenshaw, "Oh, yeah, 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 we'll hand over that stuff." But then when Hecker, the lawyer for Abrego, reached out, they were like, "No, no, no, we changed our mind." And Hecker says in his filing that the reason the government is giving for changing their mind is saying that you don't get to do Jenks material and discovery is in unless it's like trial, and this is a trial. This is pre-trial stuff, so we don't have to do it. But the lawyer Sean Hecker does a really excellent job of listing case after case after case where they say, "No, this you do have to do this in certain pretrial hearings as well. You do have to provide this information and Jenks material in order to give the defense a chance to rebut and cross-examine your witnesses during these certain pretrial hearings." And even word for word in the law and in precedent, that you do get to have access to these materials and that they are required to hand them over in certain pretrial hearings, such as this, such as a vindictive and selective prosecution determination hearing. So I don't think they've got anywhere to go, and it'll be interesting to see what the last straw is for Judge Crenshaw. I don't imagine he'll postpone this hearing again. He may just finally issue a ruling, but we will know very soon. When does the government have to? Oh, I don't think that the judge has responded to this filing by Sean Hecker yet. Has the judge
I
responded?
think the judge has ordered the government to respond by a certain date. I don't know that date off the top of my head. This is going to be briefed. He's given them the opportunity to respond, and he will issue what I believe he's doing it quickly because, again, this hearing is looming, and he might just order them. Uh, Cough up these documents already. We have to have a hearing with adversarial questioning of the government's account of this purportedly legitimate explanation as to why, after the Supreme Court ordered you to facilitate the return of Abrego to the United States, you suddenly decided, hey, time to revive this 2022 traffic stop. And now it's in our legitimate interest in investigating this case to bring this forward. That's what's at the heart of this, that this is a case that was revived uh, just, very, very shortly after the Supreme Court said you have to release Abrego. And then this new investigation began.
Yeah, and I just was able to pull up that order, that you mentioned that was issued yesterday that said the government shall reply before January 21st, 2026.
Mm,
So 5 days from now, they have.
right. So we could get a ruling of this by at the wire, and you could have Sean Hecker's team leafing through some last minute order documents, on the heels of this hearing. But as you said, Allison, I can't imagine he delays this again. This is a hearing that's been delayed twice because of foot dragging by the government, and I just cannot see Crenshaw bending over backwards once again. We'll see. The date's on the calendar. My plane ticket is purchased and my hotel is booked. So I'm planning that to be there, and I expect that it will happen.
Yeah, and I tend to agree, and I think this hearing will go off. It will go forward, and we may see a situation in the courtroom where where Abrego's lawyers say we still don't have anything, and we might get a dismissal. If I were a betting woman, I would bet that if the government doesn't produce discovery, and even if they do, I think
Hmm.
I think that we may get a dismissal. On that day, if not soon after. I think they're gonna dismiss the charges against him. I don't see even if they hand over their stuff, it's not gonna help them. I think that's why they're not handing it over is because it's devastating to their case. I don't think they're gonna be able to rebut the presumption of vindictiveness,
Well, look,
here.
we spoke on New Year's Eve when the last time they had to produce material and actually did produce material and it was unsealed, it was some jaw-dropping stuff where it was this, not jaw-dropping in the sense of unexpected, but jaw-dropping in the sense of, my God, they put it in writing. Where you had Robert McGuire, who's the acting U.S. attorney for the Middle District of Tennessee, saying, oh, no interference from Main Justice here. This isn't the political appointees. I found an honest case, and I found that Mr. Abrego, during this 2022 traffic stop that was investigated and closed, I looked into it a little closer, and he might have been
Just me,
smuggling.
no one told me to.
That's me, and he looks like he was smuggling immigrants. Lo and behold, he is coordinating with Blanche's top aide in writing, talking about, and where the aide is saying things like, "Wait for clearance on the draft indictment." Clearance from whom? So they put it in writing, and one can assume, and this is an argument that Abrego's lawyers make. They say you can assume that the reason for the delay on these disclosures is that these disclosures don't favor them. And if the standard is that they need to show a legitimate purpose, that and they aren't showing the whole thing because one assumes the whole thing isn't favorable to them, just better for the defense. That's the argument that Sean Hecker is making.
Yeah, and he's not wrong. It's I have used that clip from Liar Liar no less than 10 times when the Department of Justice fails to turn something over. Your Honor, I object. On what grounds? It's devastating to my case. Overruled. Good call. Um, they don't want to produce because it's not going to go well for them. It's inculpatory what they would probably hand over in my guess. So thank you so much for helping break all this down for us. Everybody follow All Rise News, subscribe. If you have the means, you can financially support All Rise News. That helps pay for Adam's tickets and hotels and travel to go to these court cases where he does where he has incredible coverage of them as they happen live. And definitely watch on Midas that interview with Senator Whitehouse if you get a chance. And I really appreciate you joining me today. It's fascinating. I dare say, looking forward to January 28th to see what happens, but I am also interested to see how the government responds on the 21st.
Thank you. Yeah, no, I am very interested too. And thank you, Allison, for being such a supportive colleague and for all the work that you do. And, we share uh, great interest and fascination with the cases that really affect our democracy. And so it's always great hashing it out with you. Um, we will talk again, I'm sure, after that hearing at the end of the month.
Yeah. And everybody, remember, we lose democracy in one fell swoop, and we can't get rid of this regime in one fell swoop either. So, all of these individual court cases, while they might not produce the consequences that you're looking for, they all strike a tiny blow. And when there's thousands of them, I mean, I often think, what good is my little couple FOIA requests against Doge and the Epstein files good for? Well, what it's good for is keeping the 6 Department of Justice lawyers that are left occupied so that they aren't nearly as good at their jobs.
And
So,
and to the point of your FOIA requests, you had mentioned Senator Whitehouse. He is doing the same thing you are. FOIA requests. These things matter. Using the levers of democracy, of speech, they matter. And that's Allison as well deserves your support in pursuing FOIA and these other vectors of change.
yeah, it's I always compare this administration to a house on an episode of Hoarders. It is a giant mess. You can't clean all at once, but pick a corner and start cleaning. So that's what we're doing. So thanks for watching. Thanks again. Please support All Rise News. Thank you, Adam Classfeld, and everybody. We'll see you next time on The Breakdown.
Thanks, Allison.